Jack Smith files a superseding indictment in the DC criminal conspiracy case. Welcome to Law and Society. Please subscribe and let's get started on a summary of this new indictment. Mind you, this is a new indictment that evidence was presented to a new grand jury and they came out with indictment on these four statutory violations of conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. So, as I have done before, what I'm going to do is through uh, go through this indictment and just read it up to you as there isn't much to explain. This indictment narrows the scope of the story and presents Donald Trump as the candidate and the office seeker, and also reiterates and it sort of brings into starker relief then in the indictment that what Donald Trump was doing was not part of his official duties, because election matters are not part of official duties. So I'm going to go down the whole indictment and sort of read to you parts of it that I find to be important and relevant. Here we go. Defendant Donald Trump was a candidate for the president of the United States in 2020. He lost the 2020 presidential election. Despite having lost, the defendant, who was also the incumbent president, was determined to remain in power. So for more than 2 months following Election Day, on November 3rd, 2020, the defendant spread lies that there had been outcome determinative fraud in the election that he had actually won. These claims were false, and the defendant knew that they were false. But the defendant used his campaign to repeat and widely disseminate them anyway, to make his knowingly false claims appear legitimate, create an intense national atmosphere of mistrust and anger, and erode faith in the administration of the election. So, at the very beginning, it's going to sound a lot like the first indictment, but there are parts of it where Jack Smith brings up that, Donald Trump, as a candidate and as a citizen, was exercising these private rights and employing private co-conspirators, not people who were part of the whole part of Donald Trump's official administration, with the exception of his chief of staff. They were, all private actors. So, defendant, as a candidate and citizen, had a right to speak publicly and even falsely that there was outcome determinative fraud. And he had the right to challenge them, which he did. His efforts to change the outcome of any state through contests, audits, or legal challenges were uniformly unsuccessful. Shortly after Election Day, the defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. In doing so, the defendant perpetrated 3 criminal conspiracies: a conspiracy to defraud the United States by using dishonesty, fraud, and deceit to impair, obstruct, and defeat the lawful federal government function by which the results of the presidential election are collected and counted and certified by the federal government, which is in violation of 18 U.S.C. Section 371. B, another conspiracy to corruptly obstruct and impede the January 6th congressional proceeding at which the collected results of the presidential election are counted and certified in violation of 18 USC section 1512K, and conspiracy against the right to vote and have one's vote counted in violation of 18 USC section 241. Each of these conspiracy targeted a bedrock function of the United States federal government: the nation's process of collecting, counting, and certifying the results of the presidential election. From here on, it will be known as federal government function. In future reference, when I say federal government function, I mean the bedrock function of the United States government, that the nation's process of collecting, counting, and certifying the results of the presidential election. In furtherance of his conspiracies, defendant tried to enlist the vice president. He did knowingly combine, conspire, confederate, and agree with co-conspirators known and unknown to the grand jury to defraud the United States by dishonesty, fraud, and deceit, to impair, obstruct, and defeat the federal government function by which results of the presidential election are collected, counted, and certified by the federal government. This may sound like an echo of the indictment, original one, because it is. The purpose of the conspiracy was to overturn the results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. Defendant enlisted co-conspirators, none of whom were government officials during the conspiracies, and all of whom were acting in a private capacity. So it is important, this is a newer turn of phrase that Jack Smith brings into the superseding indictment, where the prosecutor points out that none of the co-conspirators mentioned in the indictment were government officials. They were also not acting in any government capacity. They were acting in private capacity. And that's what this case turns on. And this is after the presidential immunity ruling in the Supreme Court. Co-conspirator 1 was a private attorney, 2 was a private attorney, 3 was a private attorney, 5 was a private attorney, co-conspirator 6 was a private political consultant. So through state laws, each of the 50 states in the District of Columbia chose to select their electors based on the popular vote in the state. The ECA required each state to formally determine or ascertain the electors who would represent the state's voters by casting electoral votes on behalf of the candidate who had won the popular vote, and required the executive of each state to certify to the federal government the identities of those electors. Then, on the date set by the ECA, the state's ascertained electors were required to meet and collect the results of the presidential election, cast the electoral votes based on their state's popular vote, and to send their electoral votes along with the state's executive certification that there were states' legitimate electors to the United States Congress to be counted and certified in an official proceeding. Finally, the Constitution and the ECA required that on the 6th of January following Election Day, the Congress meet in a joint session for a certification proceeding presided over by the Vice President as the President of the Senate. This federal government function, from the point of ascertainment to the certification, is foundational to the United States democratic process, and until 2021 had operated in a peaceful and orderly manner for more than 130 years. So then have a quick drink of water. Then the prosecution goes into the manner and means in which the defendant violated the law. The defendant and co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to subvert the legitimate election results and change electoral votes for the defendant's opponent, Joseph R. Biden Jr., to electoral votes for the defendant. That is, on the pretext of the baseless fraud claims, defendant pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors in favor of the defendant. The defendant and co-conspirators organized fraudulent slate of electors in 7 targeted states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, attempting to mimic the procedures that the legitimate electors were supposed to follow under the Constitution and other federal and state laws. This included causing the fraudulent electors to meet on the day appointed by federal law on which legitimate electors were to gather and cast their votes, cast fraudulent votes for the defendant, and sign certificates falsely representing that they were legitimate electors. Some fraudulent electors were tricked into participating based on the understanding that their votes would be used only if defendants succeeded in outcome determinative lawsuits within their state, which the defendant never did. And we learned later on in the indictment that the defendant knew very well, and the co-conspirators knew very well that at the time that they were telling these electors these lies, that their votes would only be counted if there was an outcome determinative change, was actually lying to these electors as well. And a lot of them in good faith believe Donald Trump and Donald Trump's co-conspirators. The defendant and co-conspirators then caused fraudulent electors to transmit their false certificates to the vice president in his capacity as president of the Senate and other government officials to be counted at certification on January 6th. The defendant and co-conspirators attempted to enlist the vice president in his ceremonial role as president of the Senate at the January 6th certification proceeding to fraudulently alter the election results. When that failed, on the morning of January 6th, defendant and co-conspirators repeated knowingly false claims of election fraud and gathered supporters, falsely told them that the vice president had the authority to and might alter the results and direct them to the Capitol to obstruct the certification proceedings and exert pressure on the vice president to take the fraudulent actions he had previously refused. After it became public on the afternoon of January 6th that the vice president, as the president of the Senate, would not fraudulently alter the election results, a large and angry crowd violently attacked the Capitol and halted the proceeding. As the violence ensued, the defendant and co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification based on those claims. So I am reading, and it may sound like a repetition of the indictment, original one, because it's a superseding indictment and a lot of the facts are true. The reason why it's a superseding indictment is because it narrows the scope of the indictment and makes it so that the actions that are being described in this indictment are narrowly focused into the defendant's private actions and actions that are not part of the defendant's official duties. The defendant was on notice that his claims were untrue. He was told so by those who invested in his reelection, including his own running mate and his campaign staff. Federal and state courts rejected every outcome determinative post election lawsuit filed by the defendant, co conspirators, and their allies. State officials issued public statements dispelling the defendants' and co conspirators' myth of widespread election fraud. National Association of Secretaries of State and National Association of State Election Directors and other organizations issued a statement on behalf of several coordinated entities declaring the 2020 election to be the most secure American election, the most secure in American history, and that there was no evidence that any voting system deleted or lost votes, changed votes, or was in any way compromised. The defendant continued to make false claims nonetheless, with deliberate disregard for the truth, including through his Twitter account. Through the conspiracies, although the defendant sometimes used his Twitter account to communicate with the public as president in his presidential capacity about official actions and policies, he also regularly used it for personal purposes, including to spread knowingly false claims of election fraud, exhort his supporters to travel to Washington, D.C. on January 6th, pressure the vice president to misuse his ceremonial role in the certification proceeding, and leverage the events at the Capitol on January 6th to unlawfully retain power. So here, Jack Smith talks about the distinction, and I believe this will be one of those things that will come up in the evidentiary hearing that the judge will have to decide, is whether what he said on Twitter was always his official act. But in the Supreme Court's ruling in Trump v. USA, the Supreme Court's majority rules that it is not just the fact that he's president that makes every conduct of his official presidential conduct. The conduct has to be looked at, and the purpose of that conduct. What was he doing in that conduct? As was he operating in his official capacity as president of the United States, or was he operating in his capacity as a private citizen and an office seeker and a candidate? And if it's an office seeker and a candidate and a private citizen, then those are private communications that the fact finder will have to determine whether to use or not. So I believe this would be one of those things that would come up at the evidentiary hearing. Quick drink of water. I want to point out at the get-go that this is an indictment that obviously will be litigated. There will be discovery on this. There will be witnesses coming out and, solidifying the claims that Jack Smith has brought. And of course, we're going to hear the opposing counter brief for, denying these claims and bringing up the defenses that Donald Trump has. But mind you, this process has already happened. And now we have come to the point where the Supreme Court has said that at the get-go of any indictment against a former president, the fact-finding court has to go through the evidentiary hearing to determine whether the acts were official or private. And that's why Jack Smith has filed the superseding indictment so that the government can essentially be more judicious and do it in a more timely manner, so the evidentiary hearing is not as confusing and long as it would be had the original indictment come into play, where every action and every statement would be brought into the evidentiary hearing. Here, the indictment is written in a way as to point out that the functions that were being conducted by the president at the time, Donald Trump, when he communicated on Twitter, both as president and as a private actor. So the fact finder has to determine, and in this case, in the evidentiary hearing, none of the communication that the president made that Donald Trump made in his capacity, official capacity as president on Twitter, can come in. But it cannot be said that Twitter, a public forum where he communicated with the public, where he was talking about private matters, that talk itself is an official act. It's not. That talk is a private act. And that's what this superseding indictment brings into clarity. Thank you for being here. Excuse me. Thank you for being here. I appreciate you being here and taking the time. This episode is going to be long, so I would recommend that you can either fast forward it when this episode is done live streaming, or read the indictment, because the indictment reading is going to take you longer than this reading of the summary of it. So moving on to the object of the conspiracy. To effect the object of the conspiracy, the defendant and co-conspirators committed one or more acts set forth below, using deceit to get state officials to subvert legitimate election results. On November 13th, the defendant's campaign attorneys, mind you, these are private attorneys. No, the campaign attorneys are separate from the private attorneys who are co-conspirators. But campaign attorneys are also different from the White House attorneys, where he operates in his official capacity. So campaign attorneys are working in Donald Trump's private capacity as the office seeker. On November 13th, the defendant's campaign attorneys conceded in court that he had lost the vote count in the state of Arizona. Defendant's campaign advisors had given him just a week earlier, which is the assessment that he had given him just a week earlier. So that day, the defendant turned to co-conspirator 1, whom he announced on November 14th would spearhead his effort going forward to challenge election results. From that point on, defendant and co-conspirators executed the strategy to use knowing deceit in the targeted states to impair, obstruct, and defeat the federal government function, including as described below. The defendant had no official responsibilities related to any state's certification of the results. So it's important to note, Jack Smith here points out the defendant had no official responsibilities related to any state certification of the election results. That power is up to the states. Yet he went after Arizona, where he went after the Speaker of the House of Arizona, and asked him on several occasions to change the election outcome. Campaign manager informed him of the claim that a substantial number of non-citizens had voted in Arizona. That was false. 8 days before, Arizona's governor certified the ascertainment of the state's legitimate electors based on the popular vote. The defendant, co-conspirator 1, falsely asserted, among other things, that a substantial number of non-citizens, non-residents, and dead people had voted. That's not the case. Defendant and co-conspirators asked the House Speaker of Arizona to call the legislature into session to hold a hearing based on their claims of election fraud. The Speaker refused. On December 1st, co-conspirator 1 met with Arizona's Speaker. Co-conspirator 1 when asked the question of if there's evidence of outcome determinative election fraud, Co-conspirator one responded with words to the effect of, "We do not have the evidence, but we have lots of theories." In his campaign speech on January 6th, the defendant publicly repeated knowingly false claims that 36 non-citizens had voted in Arizona. After Arizona House Speaker issued a public statement saying, "No election is perfect. As a conservative Republican, I don't like the results of the presidential election. I voted for President Trump and worked hard to re-elect him. But I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election." So, despite Arizona officials coming out and saying, "No, we're not going to change the results," Donald Trump still publicly repeated the false claims that non-citizens voted in Arizona. And he did so on January 6th at the Stop the Steal rally. Then go to Georgia. Defendant's senior campaign advisor informed the defendant that his claims of large number of dead voters in Georgia were untrue. On November 16th, on the defendant's behalf, his executive assistant sent co-conspirator 3 and others a document containing bullet points critical to a certain voting machine company, writing, "See attached, please see as included or almost as is in lawsuit." Co-conspirators 3 responded 9 minutes later, writing, "It must go in," and this is in all caps, "it must go in all suits in Georgia and Pennsylvania immediately with a fraud claim that requires the entire election to be set aside, and those states and machines impounded for nonpartisan professional inspection." Before the lawsuit even was filed, defendant retweeted a post promoting it. Co-conspirators 3's Georgia lawsuit was dismissed on December 7th. Co-conspirator 1 orchestrated a presentation of a judiciary subcommittee of the Georgia State Senate with the intention of misleading state senators into blocking the ascertainment of legitimate electors. The campaign's attorney, an agent of the defendant and co-conspirator 1, falsely claimed that more than 10,000 dead people in Georgia voted. That afternoon, a senior advisor to the defendant told defendant's chief of staff through a text message, "Just FYI, a campaign lawyer and his team verified that the 10K supposed dead people in Georgia is not accurate. The number was actually 12. Another agent of the defendant and co-conspirator 1 played a misleading excerpt of a video recording of ballot counting at State Farm Arena in Atlanta and insinuated that it showed election workers counting suitcases of illegal ballots. Co-conspirator 2 encouraged the legislators to decertify the state's legitimate electors based on false allegations of election fraud. The defendant issued a tweet amplifying the knowingly false claims made in co-conspirator 1's presentations in Georgia, claiming, "Wow, blockbuster testimony taking place right now in Georgia. Ballot stuffing by Dems when Republicans were forced to leave the large counting room. Plenty more coming. But this alone leads to an easy win of the state." So Donald Trump was, spreading these lies as he was being told that they were lies. And, the fact that what was, this alarm about, impounding state machines and that involved the DOJ and that involved, talking to the DOJ. And we see in this indictment that there's no reference of DOJ officials in their official capacity or unofficial capacity. So Jack Smith has taken those contexts out of this superseding indictment. So those issues won't come up at the evidentiary hearing. Moving forward, have a quick drink of water. Thank you very much for being here. And as I've said, this is going to be a longer episode, and I'm at 30 minutes already. So please stick around or come back. But I'm doing this for more than one reason. First is reading the indictment and showing where it's different from the first indictment. And the second is what I think has been my civic duty from day one, which is to tell people what the facts are. Because we don't know if there's going to be an evidentiary hearing or not. It has been now several months, and Donald Trump has successfully delayed, and the Supreme Court has helped Donald Trump delay this case so the trial doesn't happen before the election. Now, we don't even know whether the evidentiary hearing will happen before the election. So I want to read this indictment, and I want to remind every American who's listens to this to really go back to what happened and what Donald Trump did and how far he went and how close he came to smashing our democracy, to taking power. And he tried every means possible, including violent means, as we will read in this indictment. On December 8th, the defendant called the Georgia Attorney General to pressure him to support an election lawsuit filed in the Supreme Court by another state's attorney general, which sought to invalidate election results in certain targeted states like Pennsylvania. And I believe that was the Texas Attorney General's Ken Paxton's lawsuit that was thrown out by the Supreme Court. The Georgia Attorney General told defendant that officials had investigated various claims of election fraud in the state, including the State Farm allegations, and were not seeing evidence to support them. The following day, presented by co-conspirator 2, the defendant, not as president, but in his capacity as a candidate for office, moved to intervene and join the state attorney general's lawsuit. On December 11th, the Supreme Court denied the suit. So the following day, represented by co-conspirator 2, the defendant, not as president, but in his capacity as candidate for office. Mind you, the dual roles here of Donald Trump, because he was incumbent president at the time and the office seeker and candidate for office. So also on December 8th, a senior campaign advisor who spoke with the defendant on a daily basis and had informed him on multiple occasions of various fraud claims were untrue, expressed frustration, and many of co-conspirator 1 and his legal team's claims could not be substantiated. With respect to the persistent false claim regarding State Farm Arena, the senior campaign advisor wrote in an email, when our research and legal team can't back up any claims made by our elite strike force legal team, you can see why we are 0 and 32 on our cases. I'll obviously hustle to help on all fronts, but it's tough to own any of this when all just conspiracy shit beamed down from the mothership. When it's all just conspiracy shit beamed down from the mothership. So, you are seeing here a separation from Donald's campaign staff and advisors and the co-conspirators, who's Rudy Giuliani is co-conspirator 1. And I forget who the others are. Ken Chesbrough is part of it. John Eastman is part of it. I think Jenna Ellis may be one of them. And I think Sidney Powell may be also part of it. I don't know who else. in that elite strike force legal team. So here we see a discord, but remember, campaign attorneys are still operating as Donald Trump's private capacity as office seeker, not office holder. On December 10th, co-conspirator 1 appeared at a hearing before the Georgia House of Representatives Government Affairs Committee. Co-conspirator 1 played the State Farm video again and falsely claimed that it showed voter fraud right in front of people's eyes and was the tip of the iceberg. Then he cited 2 election workers by name, baselessly accused them of quite obviously surreptitiously passing around USB ports as if they were vials of heroin or cocaine, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. Thereafter, the 2 election workers received numerous death threats. Here we're talking about Ruby Freeman and Shay Moss. We know the facts as they stand right now. Rudy Giuliani owes millions of dollars to Ruby Freeman and Shay Moss, and he better pay up. He's gone to the last inch to not pay up, but now he has come to a point where he's selling his real estate to pay his legal debts. And I hope Ruby Freeman and Shay Moss get what is long overdue and get the money out of Rudy Giuliani. So that's what, I'm sorry to sort of take you away from the indictment, but that's what here we're talking about is co-conspirator 1 talking about Ruby Freeman and Shay Moss. On December 30th, mind you, this is happening in the state level, and the co-conspirators. These co-conspirators are private attorneys. These the conversations happening with state officials where Donald Trump has no official responsibility or any power to do anything about the election results. He has the lawful means, and he has lost all the lawful means at this point. On December 31st, the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his capacity as a candidate for president against the Georgia governor and Secretary of State. In advance of the filing, co-conspirator 2 acknowledged in an email that he and the defendant had, since signing a previous verification, been made aware that some of the allegations and the evidence proffered by the experts had been inaccurate, and that signing a new affirmation with that knowledge and incorporation by reference would not be accurate. The defendant and co-conspirator 2 caused the defendant's signed verifications to be filed nonetheless. So that's a conspiracy coming to fruition, a mini conspiracy going on right there within all of, each of these acts are conspiratorial acts when they are false election fraud allegations and Donald Trump knowingly signs a verification affirming that false allegation. On January 2nd, his chief of staff, Mark Meadows, who sometimes handled private and campaign-related logistics for the defendant. Mind you, this is important to point out because we're talking about the chief of staff to the president of the United States, but he was also working in a place where he handled private and campaign-related logistics. So it couldn't be possible for any of this information to get to Donald Trump in the Oval Office if Mark Meadows was not in sort of knowledge of it. He had actual knowledge of it or constructive knowledge of it. Defendant Trump, his chief of staff, and private attorneys involved in the lawsuit against Georgia's Secretary of State called the Secretary of State. So here, Mark Meadows is working with Donald Trump, but talking to a state representative along with Donald Trump's private attorneys about elections over which Donald Trump has no authority. During the call, the defendant lied to the Georgia Secretary of State to induce him to alter Georgia's popular vote and call into question the validity of the Biden electors' votes, which had been transmitted to Congress weeks before. So you see that it's not just, he wasn't just talking about electors, fake electors going there and sending their fake votes. He was also on the other side, this parallel conspiracy of changing the popular vote in Georgia so his fake electors would then become legitimate electors. It was a multi-pronged effort. Multi-pronged effort. He called Ruby Freeman and Shay Moss professional vote scammer and hustler. In response, the Secretary of State refuted this. You're talking about the State Farm video. I think it's extremely unfortunate that co-conspirator one or his people, they sliced and diced that video and took it out of context. When the Georgia Secretary of State then offered a link to the video that would disprove co-conspirator one's claims, Rudy Giuliani's claims, the defendant responded, I don't care about that link. I don't need it. I have a much better link. So that's very Donald Trump thing to say. Then he talked about the 5,000 dead people when the actual number was 2. Talked about out-of-state voters when everyone we have been through are people that lived in Georgia, moved to a different state, but then moved back to Georgia legitimately. They moved back years ago. This is not something just before the election. In response to multiple other allegations, Georgia Secretary of State counsel told the defendant that the Georgia Bureau of Investigation was examining all such claims and finding no merits to them. So he then talked about the 11,700 votes, and he just needs those votes, and then you're going, and then he threatens the Secretary of State. So he asks for those 11,780 votes and says that the Georgia Secretary of State and his counsel could be subject to criminal prosecution if they failed to find election fraud as he demanded, stating, are you going to find that they are, which is totally illegal. It's more illegal for you than it is for them because you know that and you're not reporting it. That's criminal, that's a criminal offense. Essentially, he's threatening. Reading Donald Trump's talk is sort of disorienting because listening to him talk is disorienting. So imagine reading it. So next day, on January 3rd, defendant falsely claimed that Georgia Secretary of State had not addressed the defendant's allegations publicly, stated that Georgia's Secretary of State was unwilling or unable to answer questions such as ballots under tables, scam ballot destruction, out-of-state voters, dead voters, and more. He has no clue. So then he repeated these lies and the dead voter, that 10,000 dead people voted in Georgia on January 6th. Going to Michigan. So Jack Smith here goes through these states and what Donald Trump did. And I want to go through them with you simply because it is important for us to know in this historic indictment of what Donald Trump did in his private capacity to derail the proper certification of electoral votes and also to undermine state procedures, so much so as to plug in 11,000 votes on Donald Trump's favor to be able to say that he won Georgia. Think about that. Think about the extent to which Donald Trump went to change the outcome of the election that he lost. And he would not give up, despite his campaign advisors telling him otherwise. And the indictment can talk about the campaign advisors because they are not Donald Trump's official capacity lawyers. Those would be his White House lawyers. The only person that Jack Smith refers to in this indictment, who is an official who would fall under the rubric of a subordinate official to the president of the United States, that one only person is the chief of staff. Chief of staff, mind you, is not required to be nominated by the Senate. Also, the chief of staff is kind of like every piece of information that gets to the president goes through the chief of staff. And here, Jack Smith makes it clear that in the Georgia call, Mark Meadows was talking to the Georgia Secretary of State, was in on that call with Donald Trump's private attorneys, and they were talking about election matters. He didn't have the authority to talk about election matters, and he was enlisting his private attorneys, and there were no White House officials who were involved in that call. Quick drink, water break. Going to Michigan. On November 20th, 2020, just 3 days before Michigan's governor signed a certificate of ascertainment notifying the federal government that based on the popular vote, Biden's electors were to represent Michigan's voters, the defendant held a meeting in the Oval Office with the Speaker of Michigan House of Representatives and the majority leader of the Michigan Senate. Defendant included in the meeting by phone the RNC chairman, who joined only briefly, and co-conspirator one, Rudy Giuliani. Donald Trump and Rudy Giuliani raised false fraud claims, including of an illegitimate vote dump in Detroit. In response, the Michigan Senate Majority Leader told the defendant that he had lost Michigan not because of fraud, but because the defendant had underperformed with certain voter populations in the state. And then the Speaker and the Majority Leader issued a public statement saying the Senate and the House Oversight Committees are actively engaged in a thorough review of Michigan's election process, and we have faith in the committee process to provide greater transparency and accountability to our citizens. We have not yet been made aware of any information that would change the outcome of the election in Michigan, and as legislative leaders, we will follow the law and follow the normal process regarding Michigan's electors, just as we have said throughout this election. On December 4th, Rudy Giuliani sent a text message to Michigan House of Representatives reiterating his unsupported claims of election fraud. On December 7th, despite having established no fraud in Michigan, co-conspirator one sent a text intended for the Senate Majority Leader. So I need you to pass a joint resolution from Michigan legislature that states that election is in dispute. There is an ongoing investigation by the legislature, and the electors sent by Governor Whitmer are not the official electors of the state of Michigan and do not fall within the safe harbor deadline of December 8th under Michigan law. On December 14th, Michigan House of Representatives Senate Majority announced that contrary to defendants' requests, they would not decertify the legitimate elections or electors in Michigan. Michigan's Senate Majority Leader's public statement included, "We have not received evidence of fraud on a scale that would change the outcome of the election in Michigan." On January 6th, Donald Trump publicly repeated his knowingly false claim regarding the illicit dump of more than 100,000 votes in Detroit. So then we go to Pennsylvania. On November 11th, defendant publicly maligned the Philadelphia City Commissioner for stating on the news that there was no evidence of widespread fraud in Philadelphia. As a result, the Philadelphia City Commissioner and his family received death threats. On November 25th, the day after Pennsylvania's governor signed the certification of ascertainment and thus certified to the federal government that Biden's electors were the legitimate electors of the state, Rudy Giuliani orchestrated an event at a hotel in Gettysburg attended by state legislators. Rudy Giuliani falsely claimed that Pennsylvania had issued 1.8 million absentee ballots and received 2.5 million in return. In the days thereafter, a campaign staffer wrote internally that co-conspirators' allegations were just wrong and there's no way to defend it. So you see here again a discord between the co-conspirator Rudy Giuliani and campaign staffer who's saying that there is no evidence of election fraud. On December 6th, after 4 Republican leaders of the Pennsylvania legislature issued a public statement that the General Assembly lacked the authority to overturn the popular vote, the defendant retweeted a post labeling the legislators cowards. On January 6th, the defendant publicly repeated the knowingly false claims that there had been 205 more votes than voters in Pennsylvania. Going to Wisconsin. On February 29th, the recount in Wisconsin showed that defendant actually lost by a larger margin. So the recount proved that it had increased defendant's margin of defeat. On December 14th, the Supreme Court rejected an election challenge by the campaign. One justice wrote, "Nothing in this case casts any legitimate doubt that the people of Wisconsin lawfully chose Vice President Biden and Senator Harris to be the next leaders of our country." That same day, going back, on December 21st, as a result of the state's Supreme Court decision, the Wisconsin governor, who had signed a certificate of ascertainment on November 30th, identifying Biden's electors as state's legitimate electors, signed a certificate of final determination in which he recognized that the Supreme Court had resolved a conspiracy regarding the appointment of Biden's electors and confirmed that Biden had received the highest number of votes in the state and that his electors were state's legitimate electors. So here we have Wisconsin's governor pushing back against this fraudulent movement of Donald's conspiracy. On the same day, defendant issued a tweet repeating his knowingly false claim of election fraud and demanding that Wisconsin legislature overturn the election results that had led to the ascertainment of Biden's electors as the legitimate electors. So when a state is won, the electors of that winner goes to vote at the Electoral College. So here, Donald Trump was actually trying to sow discord and show election fraud in each of these states so as to change the popular vote. And then there was a parallel case of the electoral vote that he was trying to shift, by sending the fake electors in place while these litigations were going on so as to delay the certification process. This whole thing was an engine moving to stop the certification of votes and for President Biden to take power. And on January 6th, defendant publicly repeated knowingly false claims that there had been tens of thousands of unlawful votes in Wisconsin. So this indictment, I'm reading this, and this may be a verbose episode, but I'm doing this because it is important for us to see what Donald Trump did, to be reminded of what Donald Trump did the last time when he lost the election. We are seeing that Donald Trump's aides and allies are working right now to say that the election that'll happen in November is rigged and is trying to get fake electors to be in charge of elections in the various states so as to corrupt the election process. We are revisiting this superseding indictment, and I'm reading as much of it as I can without reading the whole thing, and that would be going a little overboard with giving you, we're all already at an hour. So I'm doing my best to keep it short, but I believe that people need to know this. Then Jack Smith goes on to the section of the defendant's use of dishonesty, fraud, and deceit to organize fraudulent slate of electors and cause them to transmit false certificates to Congress. On December 20th, defendant and co-conspirators developed a new plan to marshal individuals who would have served as defendants' electors had he won the popular vote in the 7 targeted states, and caused those individuals to make and send to the vice president and Congress false certifications that they were legitimate electors. Under the plan, the submission of these fraudulent slates would create a fake controversy at the certification proceeding and position the vice president presiding on January 6th as president of the Senate to supplant legitimate electors with defendants' fake electors and certify the defendant as the president. The defendant had no official responsibilities related to convening of legitimate electors or signing and mailing of their certificates of vote. Mind you, he had no power in engaging with state officials in election matters, and he has no official responsibilities related to convening legitimate electors, but he did it nonetheless. The plan capitalized on ideas presented in memoranda drafted by co-conspirator 5, Kenneth Chesbrough, who was the first person to come up with the fake elector plan, an attorney who was assisting the defendant's campaign with legal efforts related to a recount in Wisconsin. So there was the Wisconsin memo that advocated that because of the ongoing recount in Wisconsin, defendants' electors there should meet and cast the votes on December 14th, the day the ECA required, to preserve the alternative of the defendant's Wisconsin elector slate in the event defendant ultimately prevailed in the state. So then they implement this whole thing and send it out to the various states. On December 6th, there's the fraudulent electors memo, and it highlights that these electors, Donald's electors, would have to meet and mimic as best as possible the actions of the legitimate Biden electors. That on January 6th, the vice president should open and count the fraudulent votes, setting up a fake controversy that would derail the proper certification of Biden as president-elect. So then there's the fraudulent elector instructions, which was a December 9th memorandum that included instructions on how fraudulent electors could mimic legitimate electors, and noted that in some states it would be virtually impossible for the fraudulent electors to successfully take the same steps as legitimate electors because state law required formal participation in the process by state officials or access to state resources. So the knowledge of corruption, the corrupt intention that is necessary in the conspiracy is being developed here by Kenneth Chesbrough and the defendant. We're talking about instructions of how to create these fake electors so they could mimic the real electors because they were the real electors based on the popular vote. And defendant was actively present. Defendant's campaign took Wisconsin memo and expanded it to any state that the defendant claimed contested. On December 6th, defendant and co-conspirator 2 called RNC chairwoman Ronna McDaniel to ensure that the plan was in motion. During the call, co-conspirator 2 told Ronna McDaniel that it was important for the RNC to help defendant's campaign gather electors in targeted states, and falsely represented to her that such electors would be used only if ongoing legislation in one of the states changed the results in defendant's favor. After the RNC chairwoman consulted the campaign and heard that work on gathering electors was underway, she called and reported this information to the defendant, who responded approvingly. So Ronna McDaniel is not a co-conspirator because she was told that these electors would only be used in the case that the litigation that was ongoing in those states would be in defendant's favor. When we later learned that that was never their intention. On December 7th, co-conspirator received the Wisconsin memo and the fraudulent elector memo. Rudy Giuliani spoke with co-conspirator 6 regarding attorneys who would assist the fraudulent elector effort in the targeted states. And he received from co-conspirator 6 an email identifying attorneys in Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin. On the next day, December 8th, co-conspirator 5 called Arizona attorney on co-conspirator 6's list. In an email after the call, the Arizona attorney recounted his conversation with co-conspirator 5 as follows. I just talked to the gentleman who did that memo, which is Ken Chesbro. His idea is basically that all of us in all the states have our electors send in their votes, even though the votes aren't legal under federal law because they aren't signed by the governor, so that the members of Congress can fight about whether they should be counted on January 6th. They could potentially argue that they're not bound by federal law because they're Congress and make the law, etc. Kind of wild, creative. I'm happy to discuss. My comment to him that I guess there's no harm in it, legally at least, that is, we would just be sending in fake electoral votes to Pence so that someone in Congress can make an objection when they start counting votes and start arguing that the fake votes should be counted. So here we have the Arizona attorney who was consulted on this case sort of laying out what their legal non-theory is. At co-conspirator 1's direction, co-conspirator 5 sent 2 points of contact in all targeted states except Michigan, the streamlined memo and the fraudulent elector instructions, along with fraudulent elector certificates that he had drafted. I mean, Kenneth Chesbro just sort of went, and Rudy Giuliani sort of are in this mess as much as Donald Trump. Quick drink of water. Thank you for being here. I really appreciate it. And I will try to keep it as short as possible. Let's see if it can be done in the next half an hour. Now, the next day on December 11th, through co-conspirator 5, co-conspirator 1 suggested that Arizona lawyer file a petition of certiorari in the Supreme Court as a pretext to the claim that litigation was pending in the state. Co-conspirator 5 had explained that co-conspirator 1 had heard from a state official that the state provisional elector that it could appear treasonous for the Arizona electors to vote on Monday if there was no pending court proceeding. So they were sort of, making it up as it goes and saying, yeah, just file a lawsuit so we can say there's a court proceeding pending. There's no sort of valid claim or case in controversy, just file the lawsuit. To manage the plan in Pennsylvania, co-conspirator 1, co-conspirator 5, and co-conspirator 6 participated in a conference call organized by the defendant's campaign with the defendant's electors in that state. when the defendant's electors expressed concern about signing certificates representing themselves as legitimate electors, Rudy Giuliani falsely assured them that their certificates would be used only if the defendant succeeded in litigation. Subsequently, co-conspirator 6 circulated proposed conditional language to that effect for potential inclusion in the fraudulent elector certificate. Co-conspirator 5 sent co-conspirator 1 an email memorandum that further confirmed that the co-conspirators' plan was not to use the fraudulent electors only in the circumstance that the defendant's litigation was successful in one of the targeted states. Instead, the plan was to falsely present the fraudulent slates as an alternate to the legitimate slates at Congress's certification proceeding. Okay? So here, Kenneth Chesbro sent Rudy Giuliani an email that further confirmed that their plan was not to use the fake electors only in the circumstance that Donald's litigation was successful in the states where the election was being contested, but the plan was instead to falsely present the fraudulent slates as an alternative to the state slates at Congress's certification proceeding. So pretty much saying that we're lying to these people. We're including them in our conspiracy, but we're lying to these people. The deputy campaign manager responded, "Here's the thing, the way this has morphed, it's a crazy plan, so I don't know who wants to put their name to it." The senior advisor wrote, certifying illegal votes. On December 13th, at the campaign staffer's request, Kenneth Chesbro drafted and sent a fraud elector certificate. Kenneth Chesbro drafted and sent fraudulent elector certificates for the defendants' electors in New Mexico. Defendants' campaign filed an election challenge suit in New Mexico 6 minutes before noon deadline of the electors' votes as a pretext so that there was pending litigation there at the time of when fraudulent electors voted. December 14th, legitimate electors from all the 50 states formally cast their votes for president, resulting in a total of 232 votes for Donald Trump, the defendant, and 306 for President-elect Biden. On the same day, at the direction of Donald Trump and Rudy Giuliani, defendant and co-conspirator 1, fraudulent electors convened sham proceedings in 7 targeted states to cast fraudulent electoral ballots in favor of the defendant. In some states, in order to satisfy legal requirements set forth for legitimate state electors under state law, state officials were enlisted to provide the fraudulent electors access to the state capitol building so they could gather and vote there. In many cases, however, as co-conspirator 5 had predicted in the fraudulent elector instructions, the fraudulent electors were unable to satisfy legal requirements. Unlike those of fraudulent electors consistent with the ECA, the legitimate electors signed certificates were annexed to the state executive's certificates of ascertainment before being sent to the president of the Senate and others. On the evening of the 14th, chairwoman forwarded to the defendant through his executive assistant an email titled "Election Recap Final," which represented that 6 contested states, the defendant's electors had voted in parallel to Biden's electors. The defendant's executive assistant responded, "It's in front of him." So, sort of that conspiracy, that leg of the conspiracy comes to fruition, that at the same time as the real electors were casting their votes in these contested states, four electors, Donald's electors, were casting their fake votes. The defendants attempt to enlist, the next section, the defendants attempts to enlist the vice president fraudulently alter the election results at the January 6th certification proceeding. As in the original indictment, Jack Smith goes through every single time that there was an effort to contact Vice President Mike Pence and pressure him to fraudulently alter the results. When his efforts failed, defendant attempted to use a crowd of supporters that had gathered in Washington to pressure Mike Pence to fraudulently alter the results. On December 19th, there was the tweet about the January 6th, be there, will be wild. This is in Donald Trump's capacity as office seeker, not as office holder. On January 23rd, he retweeted Operation Pence card, which falsely asserted that Vice President could, among other things, unilaterally disqualify legitimate electors in the targeted 6 states. He couldn't. On December 25th, calling to say Merry Christmas, he pressured the vice president again. And the vice president says, I don't think I have the authority to change the outcome. And despite that, at the big protest rally, he went on and talked about how the vice president had the authority to do so. On January 4th, Donald Trump held a meeting with co-conspirator 2, Vice President, Chief of Staff, and Vice President's counsel. The defendant's White House counsel did not attend. So from the defendant's side, it was co-conspirator 2 representing him and them talking about electoral matters about which they had Donald Trump had no responsibility. Or as Vice President Pence, in his capacity as President of the Senate. And speech or debate clause doesn't protect Mike Pence here because he's talking to the executive. So this is one of those places where there will be a contest about it. And Donald Trump will lose because you cannot assert speech or debate clause protection while talking to the executive. It's meant to keep officers of Congress safe from an overreaching executive, not to communicate with the executive. During the meeting, as reflected in Vice President's contemporaneous notes, the defendant made knowingly false claims of election fraud, including bottom line, won every state by hundreds of thousands of votes, and we won every state. The defendant and co-conspirator 2 then asked the vice president to either unilaterally reject the legitimate electors of the 7 targeted states or send the question to the states to determine whether they were legitimate. When the vice president challenged co-conspirator 2 on whether the proposal to return the question to the states was defensible, co-conspirator 2 responded, well, nobody has tested it before. The vice president then told the defendant, did you hear that? Even your own counsel is not saying I have that authority. Defendant responded, that's okay. I prefer the other suggestion of the vice president rejecting the votes unilaterally. So here you have them talking about something that Donald Trump has no authority over. He's talking about as a candidate, talking about as an office seeker, and he's talking to Vice President Pence in his capacity as president of the Senate. So speech or debate clause does not protect him here either. On the morning of January 5th, defendant at the defendant's direction, the Vice President, Chief of Staff, and Vice President Counsel again met with co-conspirator 2. Co-conspirator 2, I think it's John Eastman, now advocated that the president do what the defendant had said he preferred the day before, unilaterally reject electors from the targeted states. During this meeting, co-conspirator 2 privately acknowledged to the Vice President's counsel that he hoped to prevent judicial review of his proposal because he understood it would be unanimously rejected by the Supreme Court. The Vice President's counsel expressed to co-conspirator 2 that following through with the proposal would result in disastrous situation where the election might have to be decided in the streets. And the same day, defendant encouraged supporters to travel to Washington on January 6th, and he set the false expectation that Vice President had the authority that he may be able to change the votes, when nothing is true, when that is not true. Also, January 5th, defendant met alone with Vice President. When the Vice President refused to agree to defendant's request, that he use his position of President of the Senate to obstruct the certification, defendant grew frustrated and told Vice President that the defendant would have to publicly criticize him. Upon learning this, Vice President, Chief of Staff, concerned for the Vice President's safety and alerted the head of Vice President's Secret Service detail. Think about that. Think about the fact that a threat by the Vice President's boss is causing the Vice President, Chief of Staff to talk to the Vice President's Secret Service detail to make sure that the Vice President is safe. On January 6th, starting in the morning, defendant turned again to knowingly false statements aiming at pressuring Vice President. He falsely claimed that Vice President would come through, call from Mike Pence to send it back, falsely stated that states want to correct their votes. All Mike Pence has to do is send it back to the states. Do it, Mike. This is time for extreme courage. So then you have, as he learns that is not going to happen, at 11:15, Vice President was called again by Donald Trump. Pence was called by Donald Trump, and Pence refused. And, it didn't stop. It didn't stop until even at the Stop the Steal rally, Donald Trump talked about how Mike Pence did not do that, and Mike Pence had not voted accordingly. And you hear hang Mike Pence chants everywhere. Shortly at 1 p.m. on January 6th, Vice President issued a public statement explaining that his role as President of the Senate at the certification proceeding did not include unilateral authority to determine which electoral votes should be counted. On the floor of the House of Representatives, the Vice President, in his role as President of the Senate, began the certification proceeding. At approximately 1:11, the Vice President opened the certificates of vote and certificates of ascertainment that the legitimate electors for the state of Arizona had mailed to Washington, consistent with the ECA. After the congressman and senator lodged objection to the Arizona certificates, the House and Senate retired to their separate chambers for objection. A mass of people broke through the barriers, cordoning off the Capitol grounds, and advanced on the Capitol building, including by violently attacking law enforcement officers trying to secure it. Beginning at 1:30, the defendant, who had returned to the White House after concluding his remarks, settled in the dining room off of the Oval Office. He spent much of the afternoon reviewing Twitter on his phone while the television in the dining room showed live events at the Capitol. At approximately 2:20 p.m., the official proceeding had to be official proceeding having been interrupted. Staffers evacuating from the Senate carried with them the legitimate electors' certificates of votes and their governor's certificates of ascertainment. The House was also forced to recess. So this is an important point here, that what would have happened had they left those, because they, Donald's foot soldiers made it into the House chamber. So what would have happened? What would have happened would be that they would have taken those and burned those. So it's like, it's harrowing even thinking about talking about it now, because it's just to think of how close we came. And at 2:20, the staffers evacuated the certificates and the certificates of ascertainment. Donald Trump issued a public tweet at 2:24 intending to delay and obstruct the certification, saying Mike Pence did not have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth. Right after that, the Secret Service was forced to evacuate the Vice President, Mike Pence, and there were chants throughout the Capitol to hang Mike Pence. Where is Pence? Bring him out, traitor Pence. So while this was happening, even after this happened, co-conspirator 1 was calling members of Congress to find a way to delay the certification. Rudy Giuliani was calling 5 senators. Co-conspirator 6 was calling 6 US senators. You have co-conspirator 1 leaving voicemail that we need you. We need you to delay it until tomorrow. And this is after the insurrection. And then saying, co-conspirator 1 saying that Vice President's actions had been surprising, and asked the senator to object to every state and kind of spread this out a little bit like a filibuster. So it's like, stop the proceeding, telling members of Congress to stop the proceeding. No authority as in his official capacity, and clearly a criminal offense of a conspiracy, layers and layers and layers of it. And the attack obstructed and delayed certification for 6 hours. Later on, the joint recession convened at 11:35 p.m. and at 3:41 a.m. on January 6th. On January 7th, at 3:41 a.m. at January 7th, Vice President announced the certified results of the 2020 presidential election in favor of Biden. So this is the indictment. And then there's the counts, each of the counts, count 2 being the conspiracy to obstruct, count 3 being actually obstructing, and count 4 being deprivation of rights, of all our rights to vote and to have our votes counted. And you see in this that Jack Smith has narrowed this case to conduct that is private, to campaign conduct, to private co-conspirators. So there's not just a discord between the campaign staff who are not working in Donald Trump's official capacity, working in Donald Trump's candidate capacity, office-seeking capacity. There's a divide between them and the co-conspirators who are named as co-conspirators in the indictment. You see that there is a conspiracy happening at each level that has to be connected with one on the other and the other. And these co-conspirators are orchestrating all of it, lying to the electors, saying that we will only use your electors' signatures if we win in court, when they don't have any intention of doing that. And the email memorandum stating that is a clear example of an instance of corrupt intent, and every single time Donald Trump goes on with the false claims, knowing they're false claims, there's corrupt intent there. And they are not official acts, and they don't fall anywhere in the ambit of Donald Trump's official acts. And I believe that this indictment will shorten the evidentiary hearing, because any indictment against a former president, according to USA versus Trump, has to go through an evidentiary hearing to see that there are official acts. Jack Smith has very, very carefully taken out interactions with officials, except for with Mark Meadows, about or the transference of information from the assistant to Donald Trump, saying that Ronna McDaniel said this, and communicating with Ronna McDaniel, that's his assistant, and then there's Mark Meadows. With the exception of that, there's no DOJ, there's no talk of the DOJ meeting, there's actually no talk of that big Will Be Wild, the big meeting that happened before Will Be Wild, where it was insane, and campaign officials and Donald's White House officials and his elite strike force team were all in there. Jackson has taken that out, and you can see that even without it, there's so much information and so much criminal action, and you can see much clearer that Donald Trump's efforts to subvert the election. So with that said, I'm going to stop now and just say that this is 4 or 5 minutes shorter than the first indictment video. So please hasten the video to increase the speed of my talking, because I generally talk slowly. And here I was reading like a lot of legal statements. So thank you very much, and I will talk to you soon.